Welcome to InFringe at Your Own Risk.
Welcome to InFringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm your host, Lisa Mosbey, and today we're talking about trade secret theft. Rand will explain what happens when confidential information walks out the door with an employee and what businesses can do to protect themselves before and after this happens. Rand, thank you so much for diving into the weeds on this one.
Unfortunately, this is a sad one, and I've seen it tank many a company over the years.
Yeah. How does the law define a trade secret and what makes certain business information legally protectable?
Trade secret, everyone thinks of some fancy formula or something locked in a vault somewhere, and it's actually much, much broader than that. It's really any confidential information that provides a business a competitive advantage by knowing the information. It can be information that otherwise is publicly available if it's structured in such a way that it provides you an advantage. And the most common type of information, it's the biggest threat to companies, is your customer list. Okay? People think, oh, well, I don't have any trade secrets. Yeah, you do. Who are your customers? Because when your employee decides they want to go into competition with you, if they walk out the door with your customer list, they know who your customers are. They probably know how much the customer is paying. They may know when the customer orders typically. And those are huge advantages. If I'm cold calling companies and I want to sell even say lawn care services, right? Well, how often do they get their lawn mowed? How much do they pay? I don't know all of those things. And so I have to call a lot of people and investigate. I don't even know who uses a lawn care service and who cuts their own lawn, right? So it's a lot of work. But if I can steal my employer's customer list, I now know customers who I know use lawn care services. I know about what they pay. I can know how frequently they get their lawn mowed. And now I'm at a competitive advantage because I can go in and say, well, Jim, I know you're paying $45 a month to have your lawn mowed. We'd like to come in and do it for you for 40. Okay, well, I can take that $5 off because I don't have all of the expenses that my employer had getting him as a client in the first place. So now I can just drop the price a little and I can step in. And I'm going to know when they buy, right? If it's a company that usually buys every June because summer's their busy season, so they're going to buy the product in June, I can show up in May and say, hey, you know what? We've got a great deal for you. Here it is. And I find something that gives me an advantage over my employer, hopefully it's a former employer. You're really unethical if you're doing it while you're still work there. But I've seen it happen many times, unfortunately. And I can now bid on that project. I probably have contact with the people who are doing that. They may know me more than they know my actual employer. And so it's a huge risk. And I've tried to tell companies over the years, your biggest threat to your business is not your competitor. It is your employee. And I have seen companies that literally dissolved overnight because 2 or 3 top employees packed up everything, got all the information, left, went into competition, and then started a campaign against their former employer, bad mouthing them. Oh, they're going out of business. Did you know that? Well, that's why we left, because we knew they were going out of business, but we're here for you. We're going to be committed. And with a little bit of tortious interference and stealing a customer list, you can have, instant company, just add a customer list. And it's very unethical, but it happens all the time. People think they're entitled to it. I worked there for 20 years, so I'm entitled to take these things. And unfortunately, companies rarely do what you're supposed to do with confidential information, and that's keep it confidential. right? If it's just sitting out on your front desk and everybody can see who all the customers are and how much they pay, you have a huge problem. You want to segment that information. The salespeople need to know who they're selling to, but they don't need to know who the customers are in another area. They don't need to know how frequently that person gets their lawn cut. They don't need to know all of that information. And if you can segment that, it makes it harder for employees to try and raid the company.
Another one that comes to mind is suppliers. Who are you using? Those contracts are pre-negotiated, so you have a leg up when it comes into purchasing things. So we have lists of customers, we have suppliers. What types of other confidential information are most commonly taken or misused when employees leave a company?
A lot of it is your future business plans. As companies get bigger and they start having future business plans, small companies, it's my future business plan is to still be in business at the close of day tomorrow. As a company gets bigger, they chart things out more. And okay, we're going to develop this technology over the next 2 years. Well, if somebody leaves and they know the direction that the company is heading, and they go to that company's competitor, now the competitor may know, oh, they're going hard into AI. Okay, well, how do we respond to that? Well, maybe we need an AI group. Okay, so somebody who wouldn't have had one is now adopting one to compete. Or they know, hey, AI has problems. Let's attack the other company on, they're trying to go AI, but AI has issues. One of the big things, everything is AI nowadays. They push it everywhere. One of the big problems in the legal community is AI doesn't really know everything. It just thinks it does. And so AI search engines will create a case. If I really want a case that says X, sometimes the AI engine will create that case, right? Which is fine if you're creating stories and stuff. But if I'm filing a legal brief with the court and the court goes to look up the case I'm citing, because I've got this great quote that helps my case and the case does not exist, that's really bad. And this has happened over and over and over in the legal community over the last 2 years, where even some very well-known firms, white shoe New York firms, have been caught submitting briefs to a court that had made up cases. Or the common, it's become so common in law, it's called a hallucinated case, where and someone does it. And you would think if you're charging $1,000 an hour and you're the big New York law firm, somebody would have taken time to read the brief and make sure that all the cases say what they say they did, but nobody did. And there's been prosecutors who have been suspended for filing cases like this. One law firm got fined $130,000 by a court because there were so many. And ironically, the opposing party got chastised for not catching it. The court caught it, not the opposing attorneys. So, if you know the direction somebody's going, you can plan your competitive strategy against that, right? And so if I know that a legal service is going heavy into AI, I can come in and say, oh, you know what we're going to do? We're going to say, hey, look, AI is really risky. It has all of these problems. And then I can say, well, we're going to do AI too, but our AI, we keep our litigation documents separate from our AI. And then every time AI writes a brief, we automatically check it back against our database of cases that isn't contaminated with the AI. So we know anything it cites, if it doesn't match our database, we flag it. Okay, that's a great strategy. And that's the legal company that comes out with that right now is going to make a ton of money because everybody wants to use AI, but they don't want to get sanctioned and have their bar license at issue. But if I know the direction somebody's going, I can attack that. And in any field, if I know what you're planning on doing as my competitor, I can use that. So that's the kind of the second big thing. And then, the one that everybody thinks of is the secret formula. whether it's KFC's herbs and spices or the recipe for Coke. I think on a previous episode, I've talked about an employee at Coke decided that she was going to make some money and actually got the formula for Coke and called Pepsi and said, "Hey, I have the formula for Coke." And so they set up a buy. What she didn't realize is that the folks at Pepsi were ethical. And so the people at Pepsi, when she showed up, weren't Pepsi employees, they were FBI agents. And I think she got 5 or 6 years in prison for trying to sell Pepsi that, trade secret recipe. So there's all sorts of recipes, but the reason Coke still has that trade secret is because Coke protects that trade secret. It makes sure that, not every employee gets to see the secret to Coke. And there are restaurants who do the same thing, right? There's a lot of franchises that will pre-mix the ingredients that they sell to their franchisees. So the franchisees don't have it, because what'll happen is we have a falling out. The franchisee starts their own restaurant. Well, if they know the recipe, they can make it taste just as good as when they were, whatever brand chain. But if it's pre-mixed, they don't know exactly what's in it. It makes it a lot harder to replicate. So protect your trade secrets. Make sure you keep things confidential. Most importantly, protect your customer list and your supplier list, because those are two things that, it's a lot of work to establish those things. Make your competitors establish that on their own rather than using yours as the cheat sheet.
And I'm curious, Rand, what steps do businesses actually need to take to ensure that that information qualifies as a protected trade secret under the law?
Well, it's neat to know who, everybody in a company needs access to certain information, right? And the key is providing those people with the information they need, but not providing them information that they don't need. And sometimes that's customer data as well, not just from the competitive part, but if you work at a financial institution, you want to make sure your employees aren't taking information out the door that's going to get you sued by your customers because, hey, somebody found out that there's a deal going on and they went and bought a bunch of stock. Now we have an insider trading scandal. So just good compartmentalization of information is the way to do it, and making sure that you're taking reasonable steps to keep the information confidential.
And in your experience, Rand, do you think confidentiality agreements and non-disclosure agreements work to enforce those trade secret rights?
They can. They've become increasingly important because a lot of the states and even the FTC has been trying to get rid of non-competition agreements. They've been abused by some companies, and so they want to get rid of all of them. And sometimes it's really hard if someone's going to a competing company to keep your information confidential. But confidentiality agreements are important because they show that you're trying to protect the information, right? You're contractually obligating the people who get the information to not disclose it. And so confidentiality agreements, non-disclosure agreements, non-solicitation agreements are another way of dealing with that issue. If you say, look, you can go out and compete with us, but you can't contact any customer of ours that you've done work with in the last 3 years, something like that. Okay. Then they're allowed to go out and perform their livelihood, but they're not allowed to use your customer list to start their business. So
That seems
very
fair.
important agreements to have.
When a company suspects that their trade secret was misappropriated, what immediate action should be considered to preserve evidence and maybe minimize the damage?
First thing is contacting your IT support staff. In fact, this applies to any time you're in a legal dispute. You need to contact your IT support staff right away and tell them not to destroy things, because we develop so much data, right? In just everything we do, that periodically we're getting rid of stuff. If an email is over 180 days, delete it. Well, when you're in a lawsuit, you can't do that. You got to preserve evidence. And so you make sure that you're preserving things. And often in trade secret cases, if you make sure you preserve the communications of the party, you'll find things like, oh, look, they've been emailing our customer list to their Google account, a Gmail account. That shouldn't happen. That's pretty good red flag that they're using, they're planning on using your customer list or other information like that. So make sure your IT people have a protocol for preserving information, especially if you have somebody who's leaving and you think there may be some hanky-panky going on. Documenting that, keeping those emails, because often they're treasure troves of evidence that they were engaging in unethical conduct.
And we've talked about this in past episodes, the collaboration that goes on within companies. So in competitive industries like technology and medical device, how do companies balance collaboration among employees with the need to restrict access to that sensitive trade secret information?
That's really hard, and you've got to just decide, okay, how much restriction do we need to have on that information? If it's vital information in the company, you have a few trusted employees and that's it. And they know they can work with other people on the outside, but this information doesn't go out the door. And it's a difficult balancing act, because if you're too restrictive with your information, you don't get any benefit out of it. Because if enough people don't know, you can't function. But if too many people know, you can't keep it a secret. So it's the old joke about, can you keep a secret? Yeah, well, so can I.
I follow you there.
But it's a challenge. You really have to balance what's it worth to you.
So, Rand, for growing businesses, building teams, and developing proprietary processes, what long-term practices help reduce the risk of trade secret disputes before they arise? What do we want people to be aware of? What actions do we want folks to take today?
Know what your confidential information is. It's important to you. Your customer list, the formulas that you need, the secret sauce, whatever the recipe that you use, whatever that is. Know what it is. B, determine how you can compartmentalize things to allow the people who need to know the information to have it while keeping that to a minimum. And C is making sure people understand things are confidential. If you've got a confidential customer list, you should have confidential on the list, right? Then it's clear this is not to be shared, right? Instead of, well, I just printed it out. And when it comes down to a court hearing and they say, I had no idea this was confidential. You say, well, did you see the large capital letters on the bottom of the page that says confidential, do not disseminate? If you have that, the jury is going to much more believe that you were treating this as confidential information than if you just have, 20 stacks of the same information, no designation on anything, that were sitting in the coffee table in the front office. So just designate things confidential, make sure people know that it's confidential, compartmentalize, and always be reevaluating. Okay, what information do we have? And sometimes you're going to say, you know what, this isn't confidential anymore. The whole industry has now figured this out. We don't need to keep this certain technology confidential because everybody's using it, right? Because it's part of it is that can't be known by others. And you look kind of silly if you're saying, this is confidential. What is it? Well, it's our recipe. You mean the same recipe that's been in 12 cookbooks for the last 5 years? At that point, the cat's out of the bag. You really don't need to protect that recipe. So those are the balancing acts you get to weigh. And, it's always easier in hindsight.
It is. Hindsight is 2020. Thank you so much for going into the weeds, for diving into the details on this one today, Rand. I appreciate your time.
No problem.
That's it for today's episode of Infringe at Your Own Risk. If your business relies on confidential information or proprietary processes, taking proactive steps now can make the difference between protection and costly litigation later. To learn more or connect with Rand and his team, visit batemanip.com. And don't forget to subscribe, leave a review, and share this episode with someone who might need it. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.